Counsel for appellant ready to proceed?
May it please the court, my name is Nathan Adams. I represent appellants U.S. Ark Florida and several named members. Appellants asked to reserve 4 minutes rebuttal time. Let me begin with what this case is not about. This case is not a challenge to the constitutional authority of FWC to regulate animals in the wild, nor is it a challenge to the authority of the legislature to regulate captive animals. Instead, this case is a challenge first to the constitutional authority of FWC to issue rules regulating captive animals, including domesticated ones, and second, to issue them in disregard of due process with the effect of shuttering an industry. To this extent, our facts are more serious than the Florida Supreme Court confronted in Barrow v. Holland in 1960, when the court disagreed that FWC's predecessor agency, the Game and Freshwater Fish Commission, or GFC, could regulate the ownership of, quote, dogs, cats, and other household pets. Why did it disagree? Because the justification for the establishment of GFC, like its successor, FWC, quote, stems from the state's interest in animals ferae naturae, unquote. Wild animal life, within the meaning of Article 4, Section 9, is in fact ferae naturae. For this case, the significance of constitutional amendments since 1960 is only this. Article 4, Section 9 requires due process. The 2007 APA calls the failure to provide due process, the failure to provide a statement of estimated regulatory costs, quote, a material failure to follow the applicable rulemaking procedures. And this court, in fact, invalidated a rule.
Now, we don't need to get to those issues if we agree with you on the first issue, right?
Yes, Your Honor, you're correct. We have two separate grounds here for the same arguments that we're making today. Let me begin with, I guess, focusing for a minute on the amendments that the appellee has argued somehow render Barrow v. Holland no longer applicable. The lower court ruled that the 1967 Constitution did not list reptiles as within the authority of GFC, and that the amendments expanded FWC's authority. That is clear error. The GFC, from the beginning, had the power, according to Section 4 of Article 4, Section 30, to regulate, quote, the manner and method of taking, transporting, storing, and using reptiles. So FWC even admitted in its answer to our amended complaint that the Game Commission was created in 1943 as, quote, an independent constitutionally created agency vested with the regulatory and executive powers of the state with respect to, what? Wild animal life, using it as a synonym. And FWC enforced Article 4, Section 30 against alligator poachers in 1956. That's the Bronson v. State case, demonstrating that the kinds of animals in front of this court today were in fact in the view of GFC back in 1956. Now, the 1998 amendment is one that the appellees focus on, and that has been reviewed twice by the Florida Supreme Court. First, in advisory opinion to the Attorney General regarding fish and wildlife, and secondly, in Caribbean Conservation Corp. Inc. versus FWC. In both cases, the court found that the 1998 amendment had just two effects. One was merging the Florida Marine Fisheries Commission with the FWC, which has no relevance to today's facts, and the other one was adopting due process procedures, which we very much believe is relevant to this case today.
Well, let me just sort of get to the heart of why we're here, at least from my perspective, and that is, so it's sort of in the first round of litigation, you challenged that the legislature has the authority to regulate. It's part of the record, we've read that. You said in that litigation, FWC has the authority and the jurisdiction to regulate these circumstances. Skip forward, and here we are on appeal from your arguments that FWC doesn't have the authority, or that the rules that they've enacted, the amended rules, are unconstitutional. So who does have the authority? If you say legislature, you don't, FWC, you don't, who has the authority to regulate the reptiles that we're talking about in this case?
Your Honor, Chapter 2020-123 is the law that was at issue back in 2020. And actually, the position of the appellants in this case is entirely consistent with what it was before, and here's why. As of now, we were policing the Article 4, Section 9 jurisdictional issue. The only difference was that before, the legislature regulated wild animal life in derogation of FWC's authority, whereas this time, FWC has regulated captive domestic animals in derogation of legislative authority. And what's actually significant about that prior case, for purposes of today, is that that case meant that Florida Statute 379.372 from 2019 sprung back to life. And all of Chapter 379 is about the legislature regulating the kinds of animals that are at issue today. And we think that chapter actually supersedes and preempts the regulation at issue here with respect, again, to captive animals and domesticated animals.
But, you know, Applees didn't make a big argument about law of the case or collateral estoppel with respect to the positions that you took in the prior litigation. So let's get forward. Answer my question. Who regulates? Who's supposed to regulate in this?
It's what I actually just said, Your Honor, that the legislature
Repeat it,
is
'cause I didn't
responsible for
understand.
regulating captive animals. It has been true since 1953. We think that the record establishes that from the very beginning, from the beginning of GFC forward, Chapter 379 has been, in fact, evidence that the legislature views itself as the appropriate regulator of captive
You've argued
animals.
the legislature doesn't have the authority or jurisdiction. How is that consistent?
We argued that it didn't with respect to wild animals specifically, because Article 4, Section 9 today,
So essentially, if you put an animal, regardless of species, in a cage or in captivity, it's no longer a, quote, wild animal.
no, that's not exactly our argument. That is certainly the caricature that the appellees paint of our position. Our position in this case, the record evidence establishes that the animals before the court today are ones that have been bred over multiple generations, so-called broad stock, for the purpose of commercially selling animals. They have not been plucked from the wild and put into a cage.
So all those tourist sites we see on the interstate about come see our baby alligator,
Yeah.
that would be an animal probably captured in the wild that you would concede the commission has the authority to regulate?
Yes, Your Honor. What's critical about the Barrow v. Holland case, that a point that appellees have not admitted, is that when you look at that case, it specifically held that there are instances when captive animals are in fact subject to GFC regulation, and it referred to the incidental transport of animals as an example. It gave a couple others that were critical to the underlying purpose of what GFC is about. And we're not here to argue those kinds of facts here today. And kind of the flip of that argument, Your Honor, is if we'll call that argument by appellee the parade of horribles directed at us, the opposite issue for FWC is, okay, well, who regulates cats, dogs, and household pets? And the Florida Supreme Court clearly found that that was not appropriate for GFC. So there is a line to be drawn here. And the line that the appellants tried to argue, and that the circuit court never even mentions in its order, is that the animals in front of the court today, not only are they captive, but the record evidence is that they're domesticated. And domesticated in the same way that a fish, that a dog or a cat might be.
Well, I think, I think a profound example that was mentioned in the briefs, if I accept your argument, then if a tiger, for example, is bred in a zoo setting, so not plucked from the wild, and I buy it, and I put it in my backyard in a cage, it's your argument FWC has no authority to regulate that unless and until it escapes from my cage and then becomes wild, and then they have the authority to regulate it.
Well, Your Honor, a few points about that. The first thing is that taking animals from the wild is unlawful, irrespective of the outcome of this case. Releasing them into the wild is illegal, irrespective of the outcome of the case, by statute. And the critical point here is that it's not as if FWC doesn't have regulatory authority over these animals, that they're not going to be regulated. To the contrary, they will be regulated by the legislature. What's important about this case is that the rules were adopted solely under Article 4, Section 9, without any statutory reference. Had there been a statutory reference where the legislature had supplemented their authority to give them the authority to issue rules, we would have a different case than what we have today.
And how is that different from the argument that you made, which is, to me, in reading those pleadings that are in the record, you're making an opposite argument than you made in the 2020 litigation,
But
saying the legislature has no authority, jurisdiction, it's FWC.
Your Honor, first off, I should point out the appellants in this case are not identical with the appellants in that case. But setting that aside and pointing out that even if that case were as described by you, which I'll in a minute address and argue it is not, it doesn't change the underlying jurisdictional question here, which is, what does the word wild animal life mean? And were these rules adopted in furtherance of the jurisdiction of FWC or outside of the jurisdiction of it? What happened in 2020 is irrelevant for that purpose. But to answer your question again, what we argued before was that because the legislature was acting specifically contrary to what the rules were that FWC had adopted at that time, relevant to wild animal life, that was the reason that statute was stricken and then not appealed. Let me point out that Rule 68A-1.004, subsection 91, the rule that FWC adopted, defining not wild animal life, but wildlife, defined it as follows: all wild or non-domestic birds, mammals, fur-bearing animals, reptiles, and amphibians. That tells me that FWC even conceded that there were times when animals, including such as appellant's animal here, reptiles, could in fact be domesticated animals. And that's unrebutted testimony on the record here today. Under the summary judgment standard, once we put on record evidence to that effect that our animals were domesticated, there was a responsibility on the part of the appellee to come back and rebut it at a minimum before they could be entitled to summary judgment. And the fact that it wasn't referenced in the underlying order and that burden was never negated, that burden was never met, is reason alone from our standpoint, just looking at the burden shifting analysis of Addicts versus S.H. Kress, which of course the Supreme Court adopted a couple years ago, reason enough why it should not have been granted summary judgment in that case.
Counsel, may I ask you a question about, assuming Barrow is still binding, in other words, it informs the definition of wild animal life here in this case. Below there was a lot of argument about domestication. So where do you draw the line between when a species falls within wild animal life and then, comes out of that category? Is it domestication, and what does domestication mean? Is that kind of in the eye of the owner, or is that a more scientific-based analysis?
Your Honor, of course, a core point that we make in the briefs is that just like FWC never defined the term wild animal life, it also did not define the term domesticated. And so we have to look first at that rule I alluded to before, 68A-1.004, suggesting that wildlife, as defined by appellee, it only pertains to non-domestic, among other things, reptiles. Then we would have to look at the way DAX has defined the term, and DAX defined domesticated animals as any animals that are maintained for private use or commercial purposes to include reptiles.
Let me ask you a question that I think is a challenging question, so not necessarily dispositive, but recently the FWC declined to authorize a second bear hunt. And as I'm sure you're aware, there was quite a bit of constituent interest in that issue, especially in this area. And finally, the legislature enacted a statute that authorized citizens to kill what they consider to be dangerous bears. Did the legislature have the authority to do that, in your opinion?
Your Honor, what Article 4, Section 9 clearly says that the legislature can act in aid of FWC.
But that was a case where the commission refused to authorize the hunt. I think this has some philosophical and logical relevance.
Well-
And the argument in front of the legislature was, or at least as I perceived it, was, look, these animals are dangerous. They could kill a human being. The commission has refused to authorize, in view of some, a necessary bear hunt that could result in the death of a human being. Therefore, we, the legislature, we are going to authorize those activities. In your opinion, did the legislature have that authority?
Your Honor, clearly the legislature, as the third branch of government, is in charge of the police power here. And I suppose if where there's overlap between its unique authority in that way as compared to FWC's authority with respect to animals, I think there's a reasonable argument that you've brought to the fore on that. I see that my time, I'm going into my rebuttal time, so I'll yield that comment.
Good afternoon. May it please the court, my name is Rhonda Parnell. I represent FWC in this matter.
Now, would you mind pulling the microphone just a little lower? Thank you.
Is that a
I think
little
it'll
better?
help your voice, yes.
I'll try and speak up.
That's better.
So, Your Honor, I would kind of like to start where you ended off for the first part. The bear hunt situation is not like this situation at all. The bears that you are talking about, there's no doubt that they are wild. They are being shot when they are in the wild, regardless of whether they come onto their porch or not. So I don't think the bear hunt is a good analogy for this.
Okay, do you think the legislature had the authority to enact that law? I'm not asking you to speak for the commission. I understand that. I'm
so
asking you as a hypothetical type philosophical question. They're they're clearly wild animals. They're clearly part of wild animal life. The legislature seemingly disagreed with the commission's decision to not authorize additional hunts. The legislature said they didn't authorize a hunt, they authorized what they considered to be self-defensive actions by citizens. Did they have that authority?
Speaking as a lawyer, I would say they do not have the authority, that they usurped our authority.
Well, let's try it this
to
way.
do that. However,
I have a dog that sometimes acts wild. She won't come when I tell her to come. Sometimes she tries to run away. Does the commission have the authority to regulate wild dogs?
if it is truly a wild dog, that is a specific
Yeah,
category.
you don't have to dress my
So-
dog. So let's say dogs in the wild. There are wild dogs, right?
Yes, there are wild dogs, for example, like a dingo that would be from Australia that someone could have and release into the wild. That is a wild animal, it falls under our jurisdiction.
So what domestic animals does the commission not have the authority to regulate?
We have no regulation over domesticated animal. That
Okay, well,
falls
these
to
animals never got,
FDEX.
these animals never got out of a cage, never lived in the wild. How were these animals at issue here wild animal life?
So the FWC regulates by the species. If you were to take the DNA of one of the tegus that were in the cage and a tegu that is in the wild, it's the exact same animal. There's no difference. What the appellants are doing with their breeding is manipulating the color of that particular, in this case, a tegu. So maybe that the blue that naturally occurs in that tegu is more enhanced, it makes it a more profitable animal. But it is the same species. There's no difference to that. To
Is
give
the
you an
DNA
example,
of a wild dog and a dog the same species?
they are not. Just like a tiger is not the same as a domesticated cat, right? They have different DNA. They may be of the same genus, maybe even the same family,
So if
kingdom
a-
as you go
So if a
down.
company tries to make a profit by taking types of dogs and somehow scientifically making them more colorful or making them have certain behavioral traits that are similar to wild animals, would the commission have the authority to regulate that?
If it is a wild animal, yes. So the closest that we would come probably here would be the wolf, right? Wolf is a wild animal, although closely related to a domesticated dog. It is not a dog. It is a wolf. The DNA is separate, and that's where we draw the line, is we regulate on the species level, and occasionally it's a family level, but for the most part, it's on the species level.
So your
And
definition, the commission's definition of wild animal life is based on DNA,
it is partly,
not based on living in the wild, not based on wild characteristics, not based on roaming freely, but
it is not
Strictly
just
on
strictly.
DNA.
It is not strictly DNA. It is also based off of the wild. For example, you can have wildlife that, let me back up. There are categories of domestication. I believe Judge Thomas had asked about, or one of you had asked about the domestication. Domestication is a scientific process. It is defined by the science community. It usually takes millennia in order to do that. So for example, if we're talking about the dog, that is thousands of years. A domesticated cat goes back to ancient Egypt. It is thousands of years to domesticate it. Domestication
So
has
the
a,
commission's definition of wild animal life is essentially based on what it would consider evolutionary science?
I'm not sure I
But
understand.
you said
That would be a
you said
definition of
You
domestication.
said that domestication was a result of thousands of years of, whatever you want to call it, evolution existence. Therefore, there's no question that, dogs and cats are not wild animal life. Even though they can live in the wild, they can be totally wild. They can attack human beings in the wild.
That is true. So
But the commission would disclaim any authority to regulate wild dogs.
if it is a true wild dog, wolf hybrid, wild animal, whether you put it in a cage or whether it is living in the wild, it is under our jurisdiction. A canine that whether it is a German Shepherd, Beagle, what have you, right? They're all the same species, and that is a domesticated animal that has met the definition of domestication and is regulated through FDACS. In this particular case, what the appellants are asking is they get to make the determination of what is domesticated, ignoring science and ignoring the legislature that has made the determination on many species in the state of Florida of what is domesticated. And those type animals are your chicken, your horses, your cows, your dogs, your cats, right? And so the legislature has stepped in. They've even determined that ostriches and emus, rheas, under 379, the legislature specifically exempts some of those animals and says that they have been domesticated, even
Okay,
bison.
So the legislature can decide to exempt certain animals from the commission's authority?
Yes, they have. They've decided that those meet the definition of
So if the
domestication.
legislature decided to regulate this industry and said, okay, these reptile farms, or whatever you want to call them, these pet farms, we, the legislature, have the authority to regulate that. So would that stand in your view?
Yes, I believe that the legislature would have the ability to say, this species has been domesticated. And in this case, if they wanted to look at the tegu and decide that that is a domesticated reptile, then they
So
could
the
do
commission
so.
doesn't have the exclusive authority.
I'm sorry?
So the commission doesn't have the exclusive authority.
We do not get to make the determination as to domestication
The
for the state
legislature
of
has the
Florida.
authority to define domestication?
They do, I believe. And in this particular case, that's what they've done. Whenever they've determined that it is a domesticated animal, they have moved that over to FDACS and removed it from our situation. There are a couple times, for example, wild boar, where both FDACS and FWC have concurrent jurisdiction depending on where that boar is. So if you're raising it for meat, it may be under FDACS, but if it's roaming out in the wild, destroying your property, that may be us. So the legislature has that ability to say who is going to have that when you're talking about a domesticated animal.
So has the commission defined domestication?
To my knowledge, they have not defined domestication because that lies in the purview of the legislature for FDACS is a legislative creation and not a constitutional creation, and so they're the ones, the legislature
So
is the
tomorrow,
one.
the legislature could say, we regulate these animals that are at issue here, and the commission would step back and say, yes, that's valid.
As long as they've done it properly, I don't know that the FWC
By
would
passing
be-
a bill signed by the governor.
You know the politics involved, so you never know what that might entail. But if they were to say that tegus are now domesticated and they will be under the jurisdiction of FDACS, I do not know of any remedy that FWC would have. I mean, obviously, we could take it back to this court and you can make the decision if we decided to sue the legislature, but I don't know that that would be a reasonable option.
Going back to your example of the wild boar, where there may be dual jurisdiction, that you just gave that example. To me, that sounds like, there's a habitat distinction. So it's not species specific, it's habitat. So isn't that contrary to your previous positions or previous positions of FWC that it's based on DNA? It's a species
The
determination.
species
So how do you
swine,
drive those two positions?
the species swine has been designated by the legislature to be domesticated. They do get out in the wild, and that's where the concurrent, because of,
Well, it sounds to me like you're saying that, it becomes a, quote, wild animal if it's in a certain habitat. So that's non-species DNA specific.
well, there can be different species within the swine category. For this particular case, you are talking, there's been no designation, whether on the state level or the federal level, for any reptile that has been domesticated. So even if there is some gray area under swine, there is no gray area as to the domestication of any reptile, whether it be snake, lizard, or otherwise, on any state or federal jurisdiction. So it is self-serving for the appellants to determine that they're domesticated. They may or may not be tame for the purposes of their handler, but that does not make them domesticated. As I was saying earlier, science, when they determine a domestication, they, one of the things is to the benefit of humankind, right? That they're bred for their temperament. A wild horse, may be for riding and cattle roundups, but it also can be to pull that yoke and plow that field, right? So during that domestication, it goes through the evolution and there becomes a benefit to humankind. And if you think about what you normally think of as a domesticated animal, whether it's horse, cow, chicken, dog, cat, there is a benefit to humankind. As of right now, tegus that they are saying that are domesticated, they are only couple, 3, maybe 4 generations of breeding. That does not make domestication. Some animals can never be domesticated. There's studies that zebras, they've tried to domesticate zebras, and so far they've been unsuccessful. So for the appellants to say that their animals are domesticated, I believe is self-serving, that there's no way, just because they make the statement doesn't make them domesticated. They provided no evidence to show that anybody has ever domesticated them, that they've gone under any type of science studies or anything along those lines to show that any of the reptiles on this list are being domesticated. I would like to address, Judge Thomas, you had asked, in the first round, they challenged the legislature because the legislature adopted the 8 species that we're talking about, and they put them on the prohibited list via statute. And they challenged that, saying that they did not have the authority to put those species on there as prohibited. What counsel was saying is that they're not wild animals, right? That they can only do captive. The legislature has to regulate captive animals. But that's exactly what appellants' animals are captive wildlife. So I believe that they're disingenuous when they say that it wasn't the same attack on the first round when the legislature added them to the statute. Now, we agree that that falls under our purview, and that whether it's captive wildlife or wildlife out in the wild, that falls under our jurisdiction. Based on your example, you shouldn't be able to just go buy a tiger or a lion or a honey badger or some other critter and put it in your backyard, and because you put it in a cage, it's no longer regulated by FWC. If according to what they're asking, the legislature would have to designate that as captive wildlife, create the set of rules or what have you, or designate those to us. We do not believe that we need that designation from the legislature, because the legislature, or the language in the Constitution, it used to say that it was the regulation of bird, game, fur-bearing animals, and freshwater fish for the state of Florida. When the Constitution changed, it was, we believe that it was changed in response to the Barrow versus Holland case. The language in 1969 changed to, the commission shall exercise the non-judicial powers of the state with respect to wild animal life and freshwater aquatic life. All subsequent changes to the Constitution has remained the same. There is no doubt that that language to wild animal life expanded what animal life was, because in the prior definition, it was listing specific types of animal, right? Game animals, bird, fur-bearing.
Or could it have been more clear? Because arguably, a dog or a cat could have qualified as fur-bearing animal in the original language.
It could have been, but I mean, I believe that dogs and cats have always been domesticated, and domesticated animals do not fall within the jurisdiction of FWC.
Right, but changing it to wild animal life didn't disconnect it from the common law doctrine definition of ferae naturae, correct? I mean, it seems to me that actually more aligns more closely than the prior list of individual species.
We believe that the subsequent case law, the change in the Constitution, as well as the subsequent case law, including Wakulla, Airboat Association, Caribbean Conservation, they all, most of those were dealing with marine life, because that is a little more complicated, because it is a hybrid of both constitutional and legislative power that is given to the FWC. But we believe that, given that case law, where it has said that we are the constitutional entity, our legislative, anything that we do is tantamount to a legislative act. Our rules are the same as a statute in that if the legislature had passed a rule saying that you had to wear a blue shirt on Friday, and we did the same, our rule that said you had to have a blue animal on Friday, then our rule carries the same weight as the legislature when we make rules regarding the wildlife. The language in 379, both 303, 304, 3761, and 3762, it makes no sense as to what appellants are arguing. They're trying to argue it both ways. They're trying to say that we have no constitutional authority and the legislature has to do it legislatively. But the legislature has already done so, right? They've said under 379, 303, the commission shall promulgate rules defining class 1, 2, and 3 types of wildlife. That is what most of the animals are. A tegu was a class 3 animal. So I'm not quite sure how the appellants get to talk out of both sides of their mouth when they're saying that, because I think your question is the crux of the question, who has the authority? We believe that the Constitution, by either a common definition or other definitions of wild animal life, gives that authority to us, whether it is in a cage or not in a cage. Given the fact that we had pythons, we have Nile monitors, we have tegu populations throughout the state of Florida that make us a unique situation in wherein we not only have to protect what is current, but we're going to go forward. And it is one of the arguments that appellants are making that we can't do anything about it until we have a problem. And in this case, we are trying to prevent that problem. We would ask that you uphold the summary judgment in the circuit court. Thank you.
Sure,
With your
of course.
permission. So I want to make sure I understand both parties' arguments. And so when you use the term caged or not, and I compare that to the term domesticated, am I correct with your argument that you may have a species that is clarified as domesticated, but it may be caged? But basically what you're saying is FWC has the authority to regulate non-domesticated animals.
Yes, ma'am.
And so the reptiles that we're talking about today, if in fact they had made the list of domesticated animals as enumerated by the legislature, we wouldn't be sitting here today probably. And so it's your argument that unless these reptiles are on the domesticated list, whether they're caged or not, FWC regulates it.
Yes, ma'am. We believe that all wild animal life encompasses pretty much most of the animal kingdom except those that have been declared domesticated.
Declared by the legislature.
Yes, a
Because
legislature.
earlier you said sort of declared by science, and that.
Typically, that's how the
That raised
legislature.
some questions for me because I don't know that science is an authority under the law. So.
I think
so
science
only-
is what governs
so-
the legislature.
So the legislature declares that bears that are now feeding out of garbage cans, harassing human beings, potentially scaring people, possibly threatening human life, if they declare that they are no longer, you no longer have exclusive authority, what would be the position of the commission?
Without speaking to
But
the
I-
commission
I'm not-
themselves, I would
understand.
suspect that
I
they
mean,
would.
logically,
Yeah.
under your argument, the legislature doesn't have that authority, do they?
I would agree. I think that we would probably have to challenge the legislature if they were to declare that bears are no longer wild animals.
Has the commission filed a declaratory judgment against the recent legislation?
Not to my knowledge.
All right, thank you. Thank you. Madam Clerk, will you allow 2 minutes and 45 seconds additional time for the appellant, please?
Thank you, Your Honors. I'd just like to build on Judge Thomas, your comments. In fact, the legislature has twice decided what domesticated means, and the citations are in the briefs at Florida Statute 570.65 and 585.01 subsection 10. And what's important about that is when they did that, they directed DACS, not FWC, to then engage in rulemaking. And it was DACS that then adopted Rule 5C-30.001, specifically to define domesticated in a manner that would include the reptiles at issue in this case. And what's important here is that, again, the only record evidence here is that the animals that are in front of you are, in fact, domesticated. There's no rebuttal, competent, substantial evidence, again, meaning that the summary judgment could not be granted to the movement without addressing that issue. And Judge Thomas, I'd further say that irrespective of whether you think the FWC may regulate caged animals, reversal is required here because FWC admits it lacks jurisdiction, in fact, to regulate domesticated animals. Now,
So
further point.
who defines wild and domesticated? In other words, I assume that if the legislature declared, I don't know what's in that particular statute, it's not in front of us, obviously. But if the legislature declared that a certain animal, such as coyotes, were domesticated because they are so dependent on human civilization, obviously a court eventually decides whether an animal is wild or domesticated, but can the legislature simply make that decision?
Your Honor, I do think the challenge here, going back to the prior litigation that I understand Judge Thomas is concerned about, gets to your exact point. It is the legislature that needs to be engaged in line drawing here, and it's perfectly appropriate for the legislature to do that. And if, in fact, legislation was adopted focused on captive animals, there would be no question that it would have authority to regulate in that
So
sphere.
would you say then the legislature's authority to define domesticated animals would basically be based on the common law doctrine?
I think it is, and I think that would be the most appropriate thing.
There's no other source in the law, really, is there?
There is
To find
not.
I mean, other than a superficial reference to a dictionary, which
And-
necessarily is limited, the common law doctrine that defines whether an animal is wild seems to me to be the only controlling authority here.
I think that's right, Your Honor, and that's why the court originally said that the jurisdiction of its predecessor, FWC's predecessor agency, was derivative, in fact, of that doctrine. And that's why in State v. Lee, when there was a question whether a deer that the court said was domesticated, interestingly in that case, when there was a question whether when it was removed that was stealing or not, again, what the court did is it looked at the feri naturae doctrine. And this kind of comes full circle to another point that we make. And that is, if wild animal life doesn't mean that, there's no definition in law of the term, and there's no definition of domesticated by FWC, then there seems to be a substantive due process question. There's a vagueness question that anybody who has a household pet confronts. Is my pet regulated by FWC or is it not? And that's the kind of issue that this court has in the past, and NAACP in other cases said, means the language is not self-executing. It means the legislature has to give definition to that term, just as Judge Thomas, you were referring to earlier. And in fact, twice, both you, Judge Thomas, in the Crum v. FWC case had questions about FWC potential overreach, in that case involving marine life, and Judge Tannenbaum did as well recently in a case where the question was whether FWC regulating animals of the type at issue was within its jurisdiction or infringing on the legislature, which is, I think, what we have in this case. Even if wild animal life encompasses more than Article 4, Section 30's listing from, as originally drafted, a position that FWC has taken, it makes no difference here. It makes no difference here because even when the Article 4, Section 30 was adopted, reptiles were specifically covered, and in fact, there's a case involving, I alluded to earlier, prosecution involving an alligator. So even if there were some additional animals added, reptiles were definitely within view of GFC in Article 4, Section 30. And the critical point here is that there's nothing in the amendment sense that suggests anything to the effect that the jurisdiction over captive animals belongs to FWC. I want to end with this. Appellant Jesse Hardin put on evidence that when thieves broke into his facility and stole his tegus, FWC helped him track them down for prosecution. According to State v. Lee, this only makes sense if those animals were not wild animal life. We respectfully request that this court reverse the circuit court order granting summary judgment to FWC, remand, and direct summary judgment for appellants enjoining FWC's enforcement of these rules. With that, I'll submit the case and rely upon the briefs for anything else.
Thank you. Thank you, counsel.
Thank you.
The court is in recess.